And a development that will shock precisely no one, the court cases against AI art generative technology have started. There's one from Getty Images and there's also a class action lawsuit. Let's find out in detail exactly what that means and what the chances of success are. This one's going to have a little bit of a different format. I'm going to have to read off a script because a lot of this involves legal stuff. I am not a lawyer, a solicitor, I know nothing about trademark law, I'm an artist. However, I can read. So let's find out. There's two lawsuits. We'll cover them one by one. The first one that came up was a class action lawsuit filed against Stability AI, Midjourney and Deviant Art for DMC violations, right of publicity violations, unlawful competition and breach of terms of service. This was brought by three artists, Sarah Anderson, Kelly McKinnon and Carla Ortiz. Now this surprised me a bit that some of the bigger names in art. I'm not saying that these three people are not well-known artists, just I'm not aware of them. I'm surprised that some of the other people like Steven Salberg, haven't had their name attached to this at all. The lawsuit alleges that Stability AI Limited, Stability AI Incorporated, Midjourney Incorporated and Deviant Art Incorporated have created products that infringe on the rights of artists and other creative individuals under the guise of alleged artificial intelligence. That's quite interesting, isn't it? Alleged artificial intelligence. Is part of their case going to hinge on the fact that it's not really artificial intelligence, maybe? We'll have to find out. The Joseph Severi law firm have filed a lawsuit in the United States District Court for the Northern District of California on behalf of a class of plaintiffs seeking compensation for damages. So basically they want some money. Fair enough. If somebody's ripping off your art, you deserve to get some cash. I'm on side with that. The lawsuit alleges direct copyright infringement, various copyright infringement related to forgeries, violations of the Digital Millennium Copyright Act, the DMCA, which we all know about, violation of class members' right of publicity, breach of contract related to Deviant Art terms of service, that's a big one, and various violations of under California's unfair competition laws. Yeah, they might have them there, especially if Deviant Art's own terms of service proved that they're contravening their own terms of service. It alleges that their AI products were trained on billions of copyright images contained in the LAION-5D dataset. Try and say that with a hangover, seriously. Which were downloaded and used without compensation or consent from the artist. That is a given. That's absolute, yep, that definitely happened in that particular dataset. That's not covering all the other data sets that you can get. AI needs to be fair and ethical for everyone, said lawyer/programmer Matthew Butterick. But Stability AI, Midjourney and Deviant Art are appropriating the work of thousands of artists with no consent, no credit and no compensation. As a lawyer who is also a long-time member of the visual arts community, it's a pleasure to stand up on behalf of fellow artists and continue this essential conversation about how we, the people, want AI to coexist with human culture and creativity. Right, so he says he's a member of the visual art community. Well, I've got no reason to doubt that. I do think that a lot of this is going to depend on the exact wording of the law itself, because there's always a workaround, as we all know. The three plaintiffs are artists whose work is being used to train these generative AI tools. They're not the only three. I'm pretty sure they would admit that themselves. Anderson is the creator of popular webcomic Sarah's Scribbles. Never heard of it. I'm sure many other people have. McKern is a full-time artist whose works have been featured in galleries and who makes illustrations for comics, books and games. So she's more on the traditional art side, really. Ortiz is a concept artist and illustrator whose clients include model film studios and Wizards of the Coast. To be fair, quite a lot of artists have worked for those people. Now the second court case is different because this comes from Getty Images. And to be honest, they may well have them by the balls here. Getty Images is suing the creators of AI art tool Stable Diffusion for scraping its content. Well, I'm surprised they haven't aimed it at others as well, but maybe they're just trying to go for the root first before going for other firms. In a press statement, Getty Images said it believes that Stability AI unlawfully copied and processed millions of images protected by copyright to train its software, and that Getty Images has commenced legal proceedings in the High Court of Justice in London against the firm. So this is not LA, this is in London. That means under British law. That's quite important. The company has issued Stability AI with a letter before action, a formal notification of impending litigation in the UK. The company did not say whether legal proceedings would take place in the US as well. So that's also an option. Go for one country, try any other one. Now, why they picked the UK first, I don't know. I'm not a lawyer. There's probably a very good reason for that. Maybe it's something to do with the fact that we have slightly different laws than the rest of Europe, having had the whole Brexit thing. Because that totally worked out well, didn't it? The driver of that letter is Stable AI's use of intellectual property of others, absent of permission of consideration, to build a commercial offering of their own financial benefits, said Peters. Now, this is right. They are making money out of this. This is not like this is an open source thing like when it started out. People are making large amounts of money. And if somebody's making money at somebody else's expense, it's going to end up in a court case. We don't believe this specific deployment of Stability's commercial offering is covered by fair dealing in the UK or fair use in the US. The company has made no outreach to Getty Images to utilise our contributors' material, so we are taking action to protect our and our contributors' intellectual property rights. So this is all about money. Those guys have made loads of money off our shit. We'd like some money, please. We're not giving it to you. Right, you're going to court. That's basically what that comes down to. The lawsuit marks an escalation in the developing legal battle between AI firms and content creators for credit, profit, and future direction of creative industries. Well, yeah, we're in the middle of a war, a digital war right now. AI art tools like Stable Diffusion rely on human-created content for image training data, which companies scrape from the web, often without the creator's knowledge or consent. What do you mean, often? 99.99% of the time, it's been with nobody's knowledge whatsoever. AI firms claim this practice is covered by laws like the US Fair Use Doctrine, but many rights holders disagree and say it constitutes copyright violation. Legal experts are divided on the issue, but agree that such questions will have to be decided for certain in the courts. I suppose they would do, because they're going to make a shit pile of money out of it, being lawyers, you know what I mean? Getty Images CEO Peters compares the current legal landscape in the generative AI scene to the early days of digital music, where companies like Napster offered popular but illegal services before new deals were struck with license holders like music labels. This is correct. However, this has also meant that the companies make lots of money, the artists make fuck all. As a person who releases music on a number of digital streaming platforms, even if you have 1 million listens, you're making next to nothing. We think the similarity these generative models need to address is the intellectual property rights of others. That's the crux of it, said Peters, and we're taking this action to get clarity. Although the creators of some digital AI tools, like OpenAI, refuse to disclose the data used to create their models, that's a bit sus, isn't it, really? Stable Diffusion's training data set is open source, yes, and this is where it's going to bite them on the bum. An independent analysis of the data set from the Getty Images and other stock images sites constitute a large portion of its content, and evidence of Getty Images' presence can be seen in the AI software's tendency to try and recreate the company's watermark. Now, this is probably why one of the first things they did with Stable Diffusion was to create a flag so you could remove text from any generated images. That's probably why. It wasn't for the artists, it was to stop all this stuff. When asked what remedies against Getty Images will be seeking from Stability AI, in other words, what are they getting out of it, why are they spending all this money on a court case, Peter said the company was not interested in financial damages or stopping the development of AI art tools, but in creating a new legal status quo, presumably one with favourable licensing terms for Getty Images. That's a given, isn't it, really? They want to make sure that they protect their massive digital and physical archive. It's all about the money. So they might not want money, but they want their archive to remain one of the most used stock image archives. I don't think it's about damages, and it's not about stopping the distribution of this technology, Peters told Verve. And I think there are ways of building generative models to respect intellectual property. I equate this to Napster and Spotify. Spotify negotiated with intellectual property rights holders, labels and artists to create a service. Well, I've got something to say about that. I've already touched on it. If you are a musical artist and you're writing and performing your own stuff, you've released an album, which I've done fairly recently, unless you are a really big artist who has struck a custom deal, you will get next to nothing. The chances are the same thing's going to happen here. Unless you are a really big place like Getty Images, Shutterstock, these sort of places, they'll have special deals. The artists themselves won't. They'll make the money. The artists will make a grand total of next to fuck all. They've always done this. Why would we expect anything different of them now? So there we go, that's just the start. I think this is a case of the waters being tested legally. If one of these cases goes through and is successful, I think we're going to see a lot more court cases. And the fact that they rushed Stable Diffusion out and made it open source and therefore opened up exactly what it was using as training data, they may have just hung themselves. But again, a lot of people know a lot more about copyright law, i.e. something, than I do. But I have heard people who are trained lawyers saying, well, the thing is, the way UK copyright law is termed, they may well strike out with this one because it's quite complex and it could be interpreted a certain way. I don't know how it will affect things in the US. My gut feeling says that the likes of Disney will be rather interested because they will not want people making Disney movies, Star Wars movies, Avengers movies, and that's where it's going to end up. We all know that. We can't stop it. We can only steer it. Anyway, if this one's been quite interesting to you, watch this video, which is probably appearing up here or here, where I cover, can we stop AI? What are the threats? Where's it probably heading? So you might want to watch that one. I'll see you all next time. I'm Wayne Robson. This is Life After 3D. Bye-bye.